Hi, welcome to the Fall 2025 It's Your Money and It's Your Estate workshop series, brought to you by our 501c3 nonprofit organization, Financial and Estate Literacy. Our mission is to empower you to take control of your finances, your estate, and your charitable giving decisions. For the past 25 years, our founder, Peter Kote, as well as our entire team, have been providing these free, unbiased, and accessible 6-week workshops all over Orange County, California, as well as online, to help you make informed decisions that align with your unique needs and values. Let's start the program. This webinar is the second session of the It's Your Estate workshop series. The topic for today is Healthcare and Power of Attorney. Our moderator is Peter Kote, and our guest speaker is Fred Muscarella. Enjoy the workshop.
First of all, thank you for coming on and volunteering and making the presentation, Fred.
My pleasure.
I'm going to kind of orally go through the Ask First form. Don't put it up yet. I want to see your face and let us talk for a little bit. How long have you been in the estate planning area?
About 20 years. I know I look a little younger than than I am.
You're starting to get a little bit of gray hair.
There is a few, yeah, sprinkling.
You're one of the few attorneys that do a lot of litigation. Why is that helpful for a client?
In this field, it tells you where in these estate planning documents people could run into problems. I mean, when you do the litigation, you really start to understand what the terms of the trust or the power of attorney or the advanced healthcare directive, which provisions are really important, which are subject of disputes. And so I think it makes you a much more well-rounded attorney when you handle the litigation side of it as well.
You have an office in Irvine, I believe. Is that correct?
That is, yes. I'm not too far from the spectrum.
And do you practice in any other area besides estate planning?
I mean, probate trusts and estates, anything that's in the probate court. But yeah,
But
estate
you
plan.
don't do family law or personal injury and the like.
I do not. I mean, I've dabbled a little bit in the past, but it's not for me.
Yeah. Again, why is that important? I mean, do you refer those cases out or?
Yeah, well, it's important to focus your practice. There's just so much to know. It's unbelievable the things that you don't know that you don't even know. So
Yeah.
it's just important that I mean, there's just so much. So yeah,
Yeah.
focusing
You're
is the best way to
registered
go.
in the state of California. So we can look you up on the Bar Association to see whether or not you had any lapses in your membership to the bar.
Yeah.
People should automatically do that anytime they need a new professional. You're also a certified specialist,
I am.
I believe. What does that mean?
That means I took a second bar exam specific to trust and estates. So
Okay.
and then I had some recommendations from other attorneys and judges and
Yeah. So
uh,
it's not just it's not just a designation or a certificate that you just buy. You have to actually work for it.
Yeah, absolutely. I mean, you need to know your stuff and you have to be practicing for at least 5 years. I mean, I got it probably, yeah, about 14, 15 years ago, and I've
Yeah.
had it at all times since.
Yeah. Um, how do you the basic documents in a an estate plan is a will, is an advanced healthcare directive, it's the durable power of attorney, and it's a living trust. And then there's a change of title to the name of the living trust, and there's usually an assignment of the personal property into the trust. Approximately, how do you charge for those services?
Typically for estate planning, I just do a flat fee, so there's no surprises to the client.
Okay, and so I'm a single individual. How much would you charge me? Or remember, I am a friend.
Well, everybody is my friend. So,
So your
uh,
friendship is not worth that much.
shit. Typically, our office we charge 34.50 for a single person. If it's a married couple, it's 39.50.
Okay, and why is a married couple more?
there's more documents. I mean, you're not preparing twice as many documents, but you're preparing, an additional will, an additional power of attorney, additional advanced healthcare directive.
Yeah. And by the way, in the is that include to transfer a title, or is that an extra fee?
Yeah, now, usually I just include that. I
Include
mean,
that.
if there's more than one house, then I'll charge an extra for the filing
Okay.
for the recording fee. But generally, if it's just one real property, it's all included.
Do you charge for phone calls or initial visit if somebody is not sure whether or not they need to want to come in to see you or need to see you or they may want to make a change? Do you accept phone calls or do you charge for those?
For estate planning, I do not charge for phone calls, and what I always say is anybody that comes from your program, because you're my friend, Pete, I offer a free initial consultation.
Why don't you pull up your Ask First form? And all of that information is on his Ask First form. And you're not associated with anyone that sells annuities and the like and financial products. Is that
No, no,
correct?
I'm a straight lawyer.
Okay. Why don't you scroll down so everybody can see your address, phone number, and we'll get that.
There
Do-do-do.
we are.
Yeah. And if anybody has any questions regarding fees or how he runs his practice, please use the Q&A and we'll interrupt the session and try to get your question answered. By the way, Fred could do the entire 6-week program. And but we don't want him to do that because we want to expose you to different attorneys in the community. And so we asked him literally just to focus in on the durable power of attorney for finances and the advanced healthcare directive. Fred, why don't you pull up your outline and let's go through it.
All right. Let's make sure I'm not
And
jumping pages.
yeah, and Control L or D, there we go. And you want to start at the beginning of the,
Yeah, let's see.
here we
Okay.
go. So the first thing that you,
It's been
which
a
is
while since I
right
put
on
this
the
one together.
side, yeah, is just that because you have to know what you're doing. And do
Yeah,
you have to determine that, or do you have a medical doctor?
uh, I mean, basically, I have to make my own determination. If there's any question in my mind, I may ask for the client to, visit with a medical professional to get a letter or an opinion.
Is
Uh,
this for all the documents, for also for the will, for the trust, for the advanced healthcare directive? You have to have the same level of capacity?
well, there's varying levels of capacity, but generally speaking, I mean, the first question when a person comes into my office for estate planning, I got to make sure that they have capacity. Some people they'll call me like, "Oh, my mother, she's has dementia, but we want to change her estate plan." Yeah, we got problems in those situations.
Yeah, what if somebody has, let's say, is onset dementia, but they have good days and bad days? Uh, can you do an estate plan on a good day that they're what are you looking for?
I'm looking to determine how do they want their estate to pass? If it's just a typical, gets divided, it's a surviving spouse and she wants to, give her assets equally to her 3 children. That's easy. That's what the law says.
Uh-huh.
So I'm a little bit more comfortable if they're not sharp as a tack. I can assist the client if
But if
they,
they
but
were,
I do have to make sure that they know know what's going
yeah,
on. I got to make sure it's
and
a good day.
if they want to give their assets to their neighbor, you would really
I'm
kind of question that.
much more suspect.
Yeah.
Yeah.
What does it mean? May depend on location, time, or environment, and may be transient. Is that kind of what we've been talking about?
Yeah, because again, some people, they have sundowners. There's all different. I mean, mental capacity is it's a subject that we could just spend an hour and a half on today, but obviously we're not going to.
Yeah, the statistic I just read the other day was is that 30% of us that are over 80 will suffer from some sort of dementia or Alzheimer's. So that's a large group of people. So we got to determine capacity. Let's go to the next slide. And you're going to talk about the Advanced Healthcare Directive first?
I guess we are. So well, what
From
I was
my
going to
point of view, this is one of the most important documents.
it absolutely is. What happens is there's the medical side of things, then there's the financial side of things. And okay, money, people can make money. If you lose your money, you could still work and make more. But when it comes to your health, obviously that's the most important. And uh, having an advanced healthcare directive allows you to designate somebody in the event that you're unable to uh, give directions to a medical professional. Your agent under the advanced healthcare directive would be the one that would direct the medical professional.
Yeah, it's one of the most important documents. Let's go to the next slide. Um, Selection and discharge of healthcare providers and institutions. What do you mean by that?
So the agent under your advanced healthcare directive has a ton of authority when you lack capacity. I mean, obviously, if you have capacity, the doctor's going to take direction from you. However, if you don't have capacity, let's say you have a stroke or you're involved in a vehicle accident, and you become in a vegetative state, your agent under your advanced healthcare directive is the one that's responsible to make sure all your needs are being met, that you have the best chance of recovery that's possible.
So your advanced healthcare agent can select whether or not you live at home, whether you live in the board and care, what hospital that you're going to be at. All those are they have authority, legal authority to make decisions over.
They do, yes.
If some of those decisions require dollars, if so, let's say somebody has appointed a different person to be their successor trustee than the advanced healthcare agent. Are you making sure that they get along, or because they have to cooperate?
Yeah, I mean, generally, well, I mean, a lot of times, yeah, you'll have, one child will be the agent under the Advanced Healthcare Directive, and then maybe the other child's better with money, and maybe they're the agent under the Durable Power of Attorney for finance.
So they
Um,
have to get
it,
along.
yes, it makes things a lot easier when people get along. There's tons of room for problems when they don't get along.
Yeah, the approval or disapproval of surgical procedures, programs of medications, um, um, m- you know, do you put anything together as to the quality of life, or is it basically our try every procedure possible? How do you get into that discussion, or how does a person get into that discussion with their agent?
I mean, there are brochures and paperwork that can be completed to give more directions to your agent under your advanced healthcare directive. I mean, typically you want to go with somebody that knows you and knows your values, understands what you would have done in these circumstances. Um, but of course, if it's like if you're naming a professional fiduciary, as an agent under an advanced healthcare directive, you absolutely want to have, there's got to be more stuff in place to ensure you're giving direction to somebody that maybe you don't have as close of a relationship with.
Yeah, if I have a client that I want to know in advance, how many surgical procedures do you want to go through? If you're unconscious, for 30 days or more, what do you want me to do? There's a lot of conversations involved in making these decisions. The other thing too is, uh, do I know the prescriptions drugs that they're on? In the event
Yeah.
they go to the emergency room. Let's go to the next slide. Um, what are the types?
So Well, there's different types. Some attorneys draft their own independent, something that they came up with, an advanced healthcare directive. Then secondly, there's a statutory one that's based on a code section in the probate code. And then there's other ones, such as the CMA, the California Medical Association. They have an advanced healthcare directive. I prefer that one because doctors have seen it before. They know where to look. And that's what I use in my practice.
Yeah, I highly recommend the California Medical Association one for the same reasons. Medical doctors, nurses, they're all familiar with it, and and they give you a little card. I think it's around $10 to $15. Uh, how often do these forms go out of date?
These days, they typically don't. Years ago, they did.
Yeah, but what I find is that they get stale.
Yeah.
If I present a older advanced healthcare directive to the hospitalist at the hospital or the emergency room, their first thing is, they kind of doubt that I know what I'm talking about because, hey, it's been 10 years and the difference between 70 and 80, that's a lot of years that you might have changed your mind. And so I would say update these at, every 3 to 5 years.
Yeah, I join in that comment. I
You
think
know,
yeah, every 5 years is what I recommend to my clients.
yeah, it's too it's when you're lacking consciousness and somebody else is making the decisions for you, you want things to go as smooth as possible. Don, do you have a question?
Since I cheated on Fred and I went and looked to see if it was coming up before it got asked, are
Mhm.
these immediate or springing?
Well, typically with an advanced healthcare directive, typically it's spring, meaning that it comes into effect when you lack capacity, when you don't have the ability to instruct a medical professional.
Okay.
There is a box that you could check that says it's effective immediately, but in real life, if you can tell the doctor what you want, the doctor's going to listen to you. And then again, if
Agreed.
you can't give directions to the doctor, well, that's when the doctor turns to the agent under the advanced healthcare directive.
Okay.
Yeah.
Thank you.
And would you suggest that the agent keep a document with them?
Yeah, the Advanced Healthcare Directive, it should be, you should have multiple copies of it. There should be, obviously, one at your house. There should be, you can provide one to your doctor, and then on top of that, you should provide one to the agent, whoever's
Yeah.
listed in the document. People shouldn't be surprised that they're the agent under your Advanced Healthcare Directive. That's something you have to discuss with the agent. It's very important.
Yeah. Let's go to the next slide. This is kind of typical. You know, the the it requires two signatures, correct?
It can either have two witnesses sign in addition to the principal, or you could do a notary. So you got a little bit of flexibility there.
And when you have two witnesses signed, all they need to do is witness your signature.
Correct.
Okay. Uh, and can it be one of the agents can be one of the signatures, or does it have to be total strangers?
Well, it doesn't have to be a total stranger, but it should be individuals other than the named agent.
Other than the named
I mean,
agents.
in my office, it would be myself as well as a paralegal.
Okay.
Will typically be the witnesses.
Okay. Let's go to the next slide. Here we go. This must not be a healthcare provider or an employee of the patient's healthcare provider. Is that for hospitals and board and cares? Or
Uh,
that's the second one, probably.
so a witness may not be the patient. Yeah, I mean, it's pretty standard. You don't want any conflicts of interest.
Yeah, you want to avoid those. I've never seen that there is a problem with this issue at all in any of.
I think most people understand, and I'm sure if you're a medical provider, you don't want to be signing any documents and potentially incurring liability. So,
Yeah,
uh,
exactly. Let's go to the next slide. What does this mean? SNF patients.
so SNF is a skilled nursing facility. So if you're in if a client of mine is in a skilled nursing facility and we're executing an advanced healthcare directive, we have to get the ombudsman's signature. Ombudsman is somebody uh, that works for the county, that makes sure that people in skilled nursing facilities are not being taken advantage of, or are not being treated poorly, or neglected, so on and so forth.
Yeah, it's the ombudsman plays a major role in making sure that the board and cares are up to snuff.
Yeah.
Let's go to the next slide. This is expiration. So, yeah,
We briefly covered this earlier,
yeah,
but years ago, when I'd review an advanced healthcare directive, sometimes it would say it expires after 7 years. Nowadays, they don't have that same language, but it's something to look for. It's a little less important nowadays. It's been quite some time since that law was in effect.
yeah. Let's go to the next slide. What is HIPAA?
It's
Uh,
the Health Information Privacy Act. It's obviously your doctor's not allowed to tell other people about your medical conditions, your medical history. It's to protect medical privacy.
and it's a real pain. I mean, it's to get somebody else's medical records is a real issue and a problem for both the practitioner and for the purpose of if you're trying to get information from somebody else's medical records, but you
And it's
have to have the HIPAA release.
Yeah, so one of the documents that I prepare is what's known as a HIPAA release. And what that says is that the principal is telling the doctor or the medical professional that it's okay to release the principal's medical information to the agent that's designated under the Advanced Healthcare Directive. I mean, it's tough for the agent to do their job properly if they don't have complete information regarding, your medical history.
Yeah. Let's go to the next slide. We're dead. What do we do with the body?
So yeah, what happens is, and a lot of people they're not aware of this. So the agent under the Advanced Healthcare Directive has uh, the ability to control the disposition of your remains. So if you want to be buried, who's directing the funeral, all that stuff, well, the funeral parlor is going to turn to the agent under the Advanced Healthcare Directive. So the document, when you pass away, the document still exists and it continues on. And again, it names who's responsible for the disposition of your remains.
It could be a major issue in families. In the Jewish community, if you're one that follows the faith, you do want to be buried in a wooden box. But however, if it doesn't state that in your advanced healthcare directive, or your agent doesn't know that, it might not happen. By the way, religion plays a major part. You may want to talk to your agent to make sure is that their religion will allow them to do what you want them to do. So, I, are you going to? I can't remember if you have a slide as to who to pick as part of the agent, but let's go through the disposition first. uh, for most of us after the age of 50, um, our body parts are not that valuable, but you can donate it to a medical hospital or a student for medical studies by students. Um, a, but other than that, pretty much the cremation or burial is sometimes in a family a big issue. You may want to make sure that that gets discussed. Yes, Don.
Absolutely.
while we're still alive, I want to back up one slide. You don't have to go back, Fred. Here's my question to you became, I want to make sure that it's really clear to people because it was startling to me the first time I heard this. So I'm married, been married for 50 something years, and my wife is in trauma and I don't have an advanced healthcare directive. I can't deal with her medical care. without a HIPAA release and a medical directive. I cannot control my spouse's, or is that correct?
I mean, if you don't have any estate planning documents, they'll turn to, your significant, your spouse first,
Ooh.
and if the spouse is not there, then but again, it's good practice to name who you want.
Don, it's more or less the issue is going to be
Information?
is there conflict?
Yes.
When
Okay.
there's conflict, that's when you need these documents. You know, medical personnel are very helpful and they want to make sure that they listen to the family. The problem becomes if there's a conflict within the family.
Okay.
And then the doctor is going to ask, okay, who has the legal authority to make the final decision?
And let's go one step farther since I have a 19-year-old granddaughter. At what age do I require HIPAA release of her information to her mother, as an example? Is it 18?
Meaning that's
In other words, I
Her
have
mother wants to know what her medical situation is and therefore requests information on her medical
from the
condition.
institution.
so. I mean, when the minor's, a minor,
She's 19.
and she's an adult.
In other words, yes.
That's
So
my
you
point.
have to have you have to have an advanced healthcare directive
Right.
for your 19-year-old if
Right.
she can't speak for herself.
That's my point. Okay. That's all I wanted.
Once you turn 18, you're an adult and you have legal
Yeah. So
capacity
everybody
to
over
enter
the age of
contracts.
18 needs an advanced healthcare directive, is the
They-
point.
They
They
should have
probably
them
need many things, but that certainly is one of them. Yes. Thank you.
these days.
Let's go to the next slide. Atomical gifts. So let's just go to
And just to clarify, so for instance, in the California Medical Association Advanced Healthcare Directive, there's a whole section that talks about if you're gonna, you want to donate organs or donate your body to science or whatnot. So that's something that gets discussed with the attorney.
yeah. Let's go to the next slide. What is a DNR?
Do not resuscitate. So that's it's providing directions, to the medical professionals and family members as to, if in the event that you can be, resuscitated. Some people say, don't resuscitate me.
Yeah, but this is a completely separate order from an advanced healthcare directive.
Yes, absolutely.
It's not and and if you do have a DNR and you're at home, you may want to talk to your local fire department because they're the ones that are going to be knocking on the door in the event of an emergency. And they want to, if you can let them know in advance that you have a DNR or somebody in the family, let them know that you are DNR. It's the best thing because else they're under a duty. If they don't know you have a DNR, they're under a duty to give you CPR and to try to resurrect you. So
The law presumes that you want to stay alive.
yes, which is a good presumption.
Yeah, I'm in favor.
Yeah. What is a physician orders for life-sustaining treatment, a pulse?
So that's another separate document. And to have one, it has to involve your physician. It's got to be signed by your physician. And it provides more direction in the event of an emergency, in the event of a situation where it could be life or death. Again, it provides more directions based on what you want.
Yeah, we recommend looking at a pulse and giving your doctor, it's a doctor's order, so it's a powerful document. Um, uh, if if you have cancer or you are in the last year of your life and you want to make sure that there's an order to either that you don't want any extraordinary means to keep you alive, or if you want just comfort care, or if you want all measures taken to keep you alive. This physician's order is very, very valuable. It's pink in color, and so that it stands out in the medical file. But again, this is an alternative to the advanced. Does the advanced healthcare trump the POLST, Fred?
It does not.
It does not. The POLST, the physician's order is the go-to document then.
Absolutely. And again, to have one, you have to involve your doctor.
Yeah. Um, let's go to the next slide. All right. We haven't talked as to who to pick as the agent and how many people should you pick, and should you pick co. So talk to me about that. What kind of conversation do you have with your client in choosing who's going to be the successors, agents?
Yeah, and again, we're still talking about the Advanced Healthcare Directive.
Yeah.
Um, so what I mean, obviously it's a medical issue. So if you have, a child or a person in your life that shares values, medical values, similar to yours, that may be those are the people you need to be thinking about. A lot of times there'll be one child is, the medical professional, the other child's the money making professional. Well, frequently the clients, you put the person that's more, medically minded as the agent. I never recommend co-agents
Why
because,
not?
well, that's because they have to both agree. They both have to work unanimously to make decisions. And if one, especially in circumstances where the principal loses capacity, that's a lot of stress on a family. And so under stress, people tend to go, sometimes go different directions. And if you got co-agents, you might not be getting anything done, and it might have to, end up in court. I think we'll talk about that in a little bit, but I always recommend pick, number one person, the first person. I also, where do they live? That's another issue. If they live on the other side of the country, yeah, maybe you don't want them as your agent on your advanced healthcare directive, because you want your agent on your advanced healthcare directive to get to the hospital as quick as possible in the event that you're admitted to the hospital.
Yeah, you can't do this stuff by fax, phone, and you have to be there in person. And so where you live is just huge. Um, you also don't want to bully, you know. You come into town from out of town and you start ordering medical staff as to what you want to have done. It doesn't go over well. Uh, you know, you also want somebody who's not a wallflower. You know, there's lots of decisions that need to be made if you're in a situation where you don't have capacity to make decisions. And so, what I find is that sometimes the spouse is not the best person to be the first agent because they're so highly emotionally involved with the other spouse. So you may want to have that conversation with your spouse to see if they want that responsibility. The other thing too is what I find is that the agent is worried about making a mistake and causing your death. You know, that you may want to forgive them and say, "Hey, do the best you can, and if you make the wrong decisions, I understand. You're forgiven." Because um, whether or not how long you're going to be on life support. Is it 3 days? Is it a week? There's you know extra the in the medical language they use language such as, do you want to use extraordinary means to keep me alive? Well, extraordinary if you're in the ER may be totally normal for an emergency in the emergency room. It might be different if you're in the hospital. So you really have to sit down with a glass of wine, hopefully, and talk too, so the agent knows you. Make sure that the agent knows your prescription drugs that you're on. If you're allergic to any particular drug, because many times in the ER or in the hospital, they're not reading medical records. They want the agent there to be the advocate and to know you.
Yep.
And if the agent comes across that they don't really know your medical history, then they don't give a lot of credence to the agent as to what direction they're being given. Because the Hippocratic Oath is to keep you alive. And from my point of view, for you as a person, it's the quality of life that you want. And there's some individuals, no matter what, they want to stay alive.
And
So,
there's a section in the, again, going back to the California Medical Association Advanced Healthcare Directive, there's a section where you can provide some direction to your agent under your Advanced Healthcare
yeah,
Directive
we
on that issue.
recommend highly. There's a booklet called the Your Way. It's from the same agency, the nonprofit that does the Ask First form. It's called Help. And if you look at the blank Ask First form, the Your Way booklet is there. So it just gets you into the conversation. And you need a conversation with the agent, especially the person that you name first. How many successor agents should you recommend, or do you recommend?
I typically recommend 3.
Okay. Yes, Don.
And incidentally, since it's important, I thought I'd note the fact that Fred has listed that document under the resources section at the end of the presentation,
Super.
along with the polls and also the It's Your Way. So Fred was very
Thank you,
good at
Don.
covering that point.
I do what
All
I can.
righty. Appreciate that. Let's get into the next document. I don't see any questions on the durable power of attorney. So let's talk about the power of attorney for finances.
So now we're switching from medical
Yes.
and personal health decisions. Now we're going to money.
Yes.
And so if you, in the event that, not necessarily when you become incapacitated, but if you want to designate someone to be responsible for assets that are in your name individually, you can do so by executing a power of attorney for finance.
Well, let me stop you right there. So if I have all of my assets listed and titled in the name of the trust, the power of attorney for finances, I can't use that document.
So the power of attorney is specific as to assets that are in your name individually. Like
Okay.
your IRA account. IRA account's going to be in your name individually. Well, the agent under the power of attorney for finance is responsible for that account. But then if it's an account that's titled in the trustee is responsible for that asset. And so the agent under the power of attorney for finance, if the agent's different from the trustee, there's a difference in who's in charge of what.
Okay. So we got to make sure that if we want to use this document, we've first got to look at how is the asset titled.
Yeah, title is, I always say it's the most important thing. In our area of law, you just need to know how things are titled.
Okay. And so the what's the difference between a durable versus a non-durable power of attorney?
Durable means that it survives your, if you lose capacity, if it's a durable power of attorney, it'll remain in effect. And most powers of attorney are durable, but sometimes there's powers of attorney that are for specific issues, and sometimes those won't be durable. But
Okay. You're talking more or less about general versus limited. Let's say I go on vacation and I have my house for sale, and in the event that somebody needs to sign that contract, I do a limited power of attorney.
precisely, you can narrow down the scope of what the agent under the power of attorney is responsible for.
And then what is a general power of attorney?
General power of attorneys generally that they have broad powers to handle all your finances. Now, there's some specific boxes and language that has to be included in the power of attorney for certain issues, but a general is you're in charge of everything that's in my name individually.
You know, we were talking about the medical advanced healthcare directive that we need to give copies to lots of folks. is this also a document that we try to keep as give to as many folks as possible?
No, this one you keep a little more closer to to the chest.
Yes. You
I
don't
mean,
want to
it's
give
your
this
money,
one
yeah,
out.
yeah.
And please don't get one at a offline or at a
Stationery store.
stationery store. These are powerful documents and probably the second most litigated document there is besides the holographic will. Uh, uh,
Yeah.
we'll talk a little bit about that in just a little bit, but why is immediate versus springing so important today?
So immediate means it comes into effect once it's signed by the principal. Springing means it comes into effect upon the principal, losing capacity. So it's when does the agent under the power of attorney, when do they have authority to act? And that's one of the first, when I first look at a power of attorney, I'm like, all right, is this effective immediately or is this a springing power of attorney?
And what does that mean when immediate? So let's say you sign that document, you name me as your immediate power of attorney. Does that mean, Fred, I can go to your bank account and immediately withdraw money from that bank account if it's in your own personal name?
Generally, yes, that's exactly what it means. But I mean, some banks are a little funnier than others, but yes, you're correct.
So it's the power is there as soon as you execute that document.
On an immediate power of attorney for finance, yes.
Okay, so what is springing?
Springing means it springs into effect upon the principal, lacking capacity, and oftentimes it'll say a principal's deemed to lack capacity when two physicians, two doctors sign under penalty of perjury that you lack capacity to manage your financial affairs.
What for individuals 70 and over, what are you recommending to clients?
In terms of
Immediate versus springing.
I mean, I have a talk with them about that. I mean, is there any reason that the person would need to act now? I mean, for instance, if a client's going overseas, for a period of time, it's got to be effective immediately. But, if there's no reason for, if they're handling all their finances and they're doing just fine, I don't, springing is probably preferable. But but
Well,
it, but it does make it creates some more problems when the agent wants to act. It's a little tougher when it's springing because the
yeah,
bank's going to require much more. Sometimes they say, "Oh, you got to bring the principal into the bank," but then sometimes the principal's bedridden.
yeah,
You can't bring them to the bank.
yeah.
So
In fact,
it's an easier
insti
document if it's immediate.
yeah, institutions do not like this document.
No, they're worried. The banks are
That,
always worried about this stuff. It has
yeah,
to first go
because
to their
they're going
legal
to,
department.
yeah, they're the deep pockets. And so they're very, Bank of America, Wells Fargo, if the document is over a year old, they're very suspicious of it. And so what recommend highly is that once you have your document done, that you take it to your institution and to see whether or not they will accept that document if you have accounts that are in your own name. So if you have an account at Schwab, for example, in your IRA account, take that power of attorney to Schwab to see if they will accept that document.
And some financial institutions, they say, you got to have to complete our form. Some they have their own forms. Some of them.
And what would you recommend that they do?
Well, find out if that's the case. Step
That's
one.
one.
Yeah, and then
Should you
two,
should they complete that form?
they should speak with their attorney to make sure it doesn't do, they're not filling it out incorrectly, that they understand the document. It's something that should be, looked into.
Yeah, most times the individual, you shouldn't, you probably will want to complete that form that institution. So PERS has their own, Public Employment Retirement System has their own, Bank of America sometimes has their own, Wells Fargo has their own. Sometimes check with your IRA and um, today medical doctors are very leery of signing uh, lack of capacity because they don't want to go to court and they don't want to be sued. And so,
It's
if you're going to do springing, please don't do more than one medical doctor. Just use one medical doctor. Because if you do more than one, usually your primary care physician will sign. But if it, then at the second doctor, sometimes it's difficult unless you have a precarious situation. One of the things I haven't heard from you, Fred, is depends.
I'm sure it'll come.
Because so many
Usually,
situations are very personal and it depends on the particular situation as to
facts
what
and
is the
circumstances.
recommendation. So sometimes general recommendations that we make in this program or that the attorney makes may not be applicable to you as an individual or as a family. But most times for people over 70, immediate would be the preferred, but especially in some cases, you would want springing. We
And it's
can,
also who's the, how much do you trust the agent that you've named in the document? That's another part of it.
yeah. Would you name the same person that you've named as the trustee to be the power of attorney for finances?
Typically, you do. Typically there's one person that is the financial person. I mean, like for instance, my parents, their estate planning documents. I'm the financial guy, and then my brother's a doctor, so he's the advanced healthcare directive guy.
Yeah, I wouldn't trust you being the doctor either.
It depends.
Uh, you have statutory printed and attorney drafted. I always kind of recommend the attorney drafted one. Your comments?
Yeah, there's a lot of nuances when it comes to the power of attorney for finance. I mean, for instance, there's got to be specific language regarding ability to handle real property. If you want to give the power, the agent under the power of attorney, the ability to execute a disclaimer on your behalf, there has to be specific language. There's certain things in the law, set forth in the probate code,
Gifting.
gifting. Can your agent under your power of attorney, can they, direct the trustee or can they execute documents on your behalf? There's certain things that you should go to an attorney. It's much more complicated than people think.
Yeah. I got a question the other day about my mom is not capable of going to court. She sued her brothers, and now 3 years later, she doesn't have the willpower or the capacity to be in court. And the daughter wants to know whether or not under a power of attorney, she could act on behalf of her mother.
Yeah, usually there's a box you can check about the ability to commence or defend, court proceedings, litigation, so on and
So
so forth.
that's feasible.
Yeah, yeah, yeah.
Okay. Um, let's go to the next slide. What do you call the person? Do you call the person an agent or do you call the person an attorney in fact? When you sign documents, how does it have to read?
Uh, it could be either way. I mean, these days people more often refer to it as agent. Years ago, they'd always say attorney in fact. So it's interesting how, over the course of, even just in my 20 years of doing this, how things have changed. And I mean, it's an interesting concept how like the
Yeah,
language
most
changes.
institutions, escrows, they like the fact to do attorney in fact.
It's the
But
old way.
here again, vocabulary is important. So under the power of attorney, your agent is an attorney in fact, and they mean the same thing.
And yet you just made an excellent point. A lot of times when clients come into my office, I kind of consider myself like the translator. Like I'm going to explain it to you in English, but there
Yes.
is a separate language for all this stuff. I mean,
Yeah. And that's what
whether it be
makes it
courtroom
hard to
or
understand some of these documents. Um, Multiple agents, what does that mean? What point are you trying to make there?
well, just like under the Advanced Healthcare Directive, you can name co-agents. I don't recommend it. In the past, I've had lots of litigation cases where, the two brothers, for instance, If one said, the sky is blue, the other one would say, the opposite.
Yeah,
It,
I had two sisters, same thing. You know,
yeah.
they hated each other, and
Oh,
they're named Co.
yeah.
You know, mom, I guess, didn't realize that didn't like each other. You know, that's one of the things that you really got to talk to an attorney about is how do your kids get along? And, you know, are there issues in the family with drugs, with communication, with location? Is there some resentments that are there? Is one a bully or is one a diplomat? Your attorney can really help you pick the right individual in your family, or say, hey, you know, I strongly recommend somebody outside your family.
Yeah. Yeah. No, that,
You know,
that, that
well,
arises quite a
another
bit.
legal counsel said if you want to bring the family together, name someone outside of the family because everybody will have something in common. They'll hate the agent that you've chosen, and it brings the family together.
Well, and on top of that, especially like in the context of trusts and wills, when a person passes away, like people change, like the children change. It's money does something to people's minds. It's unbelievable. I mean, I deal with it on a daily basis.
Yeah, it
So we
does.
have a question, and let me just ask it as it's stated. Can you state that your agent can consult with certain people to make decisions for a health care? Does it need to be stated?
You can include that. That's language that can be put in. I mean, what I usually do is I have an attachment that goes with the Advanced Healthcare Directive. So I got the
Okay.
CMA form, and then I have additional pages of language that I've developed over the years. And if a client wants something, that they'd appreciate if the agent consulted with some other people to get their thoughts. Yeah, we can include that language in the attachment.
It's one of
Yeah,
the advantages of having you, Fred, is because you do a lot of litigation and you know the back end of this thing. What do people have to live with after the fact? So,
yeah.
thank
Yeah.
I
you.
try, I recommend don't get too specific just because you don't know exactly the situation that you're going to be in. So trust your agent to make the right decision at the time. Um, we don't know the future, so you just want to make sure that they do it thoroughly and have your best interest at heart. How many agents do you usually recommend in the power of attorney? Three? Is that your normal?
Yeah, three is typical. I mean, some
Yeah,
people don't even have three. And if they don't have three, sometimes what I do, I recommend, name a professional fiduciary.
yeah. And we're going to talk about professional fiduciaries when in the last session, and um, can 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 one spouse get into the other spouse's IRA account without a power of attorney?
No, the bank won't allow the other spouse to just access that, even if it is community property. The
So how, let's say the person doesn't have any documents and you need that money out of the IRA to pay for some of the expenses. What happens?
then the financial institution will say, "Oh, go get a conservatorship."
And what is that?
So a conservatorship it's a court proceeding in which
Pete, it's going to come up in just a minute. It's on
Okay.
another slide. But
Okay.
let me add one to that one. It's not only the retirement account. Can I sign on our joint tax return? I can't sign Jean's name, my wife's name.
correct. Now with that, if you have the power of attorney, you could, but
Yes, but without a power of attorney, even with 50 years of marriage, I still can't sign her name for all kinds of reasons, I'm sure. So it's one thing for the retirement account. It's another, you've got to file a joint tax return. The other can't sign it
Let's
and
go to
without a durable power of attorney.
let's go to the next slide and we'll talk a little bit about how to sign. Here it is. Jane by John Doe, her attorney in fact.
yeah,
That's
that's just
a
the general.
example as to how it should be signed. A lot of times this doesn't happen and it's still accepted. But let's go to the next slide.
And you also got to remember, different financial institutions are different.
Yeah,
So what might be acceptable to one may not be acceptable to another.
and so true.
Yeah.
Let's go to the next power of attorney for finance. Okay, let's talk a little bit because we were on the topic and we're going to get to the conservatorship slide in just a little bit. But if you don't have these documents, you need to get into the IRA. What happens?
If you don't have the documents, yeah,
Yes.
whoever needs to access it is going to have to file court proceedings and go down the route of a conservatorship, at least of the estate.
Okay. And the state conservatorship of the state means like the power of attorney for finances.
It's it has more power. Conservator of the estate has more power than the agent under the power of attorney for finance. But yes, so if you had a power of attorney for finance, and then there was also a conservator of your estate appointed, well, the conservator of the estate trumps the power of attorney for finance.
Okay.
But again, the conservatorship requires the court's involvement.
You're involved in litigation. Would you recommend people to go through a conservatorship?
I always say it's a last resort proceeding because I mean, you got to disclose so much information into public record that you're involving the court. I mean,
Well,
if you
right
filed
now, what's the length of time to get into court in Orange County?
for a conservatorship, it's like 4 or 5 months to get the initial hearing. I mean, you
That's
could do
not
a
even
temporary,
to
but
get the power, just to get the first hearing.
for the court to review what you filed and potentially approve it. And if you didn't fill out the paperwork correctly, it's going to get continued and pushed out even months past that.
Yeah, yeah. Yeah, we'll get into a little bit more as on the slide. But power of attorney, powers granted by law, other powers granted by the principal. So this document is very unique.
Yeah, you can tailor it to, what your desires are, what your needs are, what your circumstances are. Some people, there could be a situation like, for instance, like a disclaimer. I had one years ago where the power of attorney didn't grant the agent power to disclaim, and for purposes of saving like
What
millions of
does this
dollars.
claim mean? This is another vocabulary word. What does this claim mean?
Disclaimer is you're executing a document that says, treat the situation as if I predeceased. Let's say that a a child, let's say a person they've got millions and millions of dollars. They have one child, and that child has a child below them. Well, let's say that the child has millions and millions of dollars. Well, if you're trying to avoid estate taxes and tax situations, what the child can do is, upon the passing of the parent, they can disclaim their interest and execute a disclaimer, and then it's as if they had predeceased the parent, and then everything would go to the child or
So there's
the
a
grandchild in that circumstance.
so there's post planning, after death planning that you can do if you have the proper documents with the proper language.
Yeah. So what I was going to say is, yeah, there was a case years ago that I did where the power of attorney for finance didn't give the power to disclaim, and so disclaiming assets, for this individual, the principal, um, you know, would have saved, yeah, millions of dollars in taxes. And so what we had to do is we had to file for a conservatorship of the estate and get authority to execute a disclaimer on behalf of the proposed conservatee in that one.
Please don't use legal Zoom or for a power of attorney. I know it seems like such a simple document, but it really isn't. It's quite complex, and probably I would say it's the second most important document in your estate plan. Even if you don't have a living trust, you must have a power of attorney.
Yeah.
So let's go to the next slide. How do you terminate a power of attorney?
I mean, so, well, the first thing is you can revoke it. They're revocable. As long as you have capacity, you could sign a document that says, I hereby revoke my power of attorney that was executed on such and such date, which empowered, such and such as the agent. I mean, that's one way. And then you deliver the revocation document to the agent under the document, and as well as to maybe your financial institutions.
Yeah. So
Um,
keep track of the financial institutions that you have given a power of attorney to.
Correct. And then secondly, unlike an advanced healthcare directive, a power of attorney for finance, it becomes void upon your passing. So the agent named under it has no power once you pass away. I mean, the only time they do is when they don't tell the financial institution that you passed away. And But yeah, you're getting into fraud and
Yes.
potential criminals.
So this document ends upon death.
That's correct.
Does it end on incapacity?
Usually, I mean, if you make it a durable power of attorney, then it's
Okay, so you have to know
okay.
if it's a springing or an immediate.
Well, that's a different issue. But
You-
if it's going to survive you becoming incapacitated,
Okay,
if it's a durable, it'll have language in there that says that it
okay.
survives your incapacity. Now,
Principal's incapacity,
if it's dur
non-durable,
if it's durable, it'll survive. It continues in effect even
and
if
the
you're
court can
incapacitated.
revoke it.
Yeah, a lot of time conservatorship proceedings, or you can file an action under a power of attorney for finance. And yeah, absolutely, the court they've got a lot of power.
Let's go to the next slide. Okay, well, I've had situations where Bank of America has refused to honor the power of attorney. It was 15 years old, and they said they wouldn't accept it. What happens?
Well, usually the client comes to me and asks me to write a demand letter to the financial institution. But if the financial institution still won't cooperate, you say, all right, well, I'm going to file a court action, you tell the bank this, and you say, and I'm going to request a court order that you have to pay all of my fees. And there's a provision in the law that allows for that. So it's the law is
But you don't
designed
want to
to,
be there. You don't want to go there,
oh, of
unless
course
you
not. No.
absolutely have to. Uh, you more than likely want to that's why you want to take your power of attorney to your institutions to make sure that they will accept it. And once they have it on file, you usually will not have any problems because if you're in an auto accident and become disabled, all of a sudden now you need it if you have a bank account that's in your own name. So it's important to keep these documents up to date. Do do these power of attorney, do they go out of date? Do they by law?
They don't go out at a day. I mean, unless you put some specific language in it that says it does, but generally, no.
So you could
It
have
could
a
go out of
20-year
date.
old power of attorney and it still be valid today.
And depends.
Yeah.
No, I mean, let's say that your agents have all passed away. I mean, I think that was on a previous slide. Well, if all of your agents are deceased, that document's not going to help anybody.
Yeah. Yeah. So make sure your agents are younger than you, more than likely. Let's go to the next slide. Um, we're going to have a whole session on
Yeah.
trustees, so I don't want to get into that. But how does that relate to why have both documents? If you can you serve, in other words, would it be a good estate plan if you just had a will, a durable power of attorney for healthcare, and you had a durable power of attorney? You had those three documents. You don't have a living trust.
Well,
What would
the,
you say to that?
the trust of, I mean, the trust control, well, allows you to avoid probate is one of the major reasons people do trusts. Trust can also be tax, savings, or allow for tax savings procedures. They're a much more complicated document, but yeah, some people, let's say that you don't have much in assets. Let's say your net worth is $100,000. You could get by with just a will, a power of attorney, and an advanced healthcare directive. But especially if you own real property, you need a trust because if you own real property, chances are it's going to have to go to probate upon your passing.
Yeah, and
Um,
I understand the probate argument, but we just had a major discussion how difficult sometimes it is to work with a power of attorney with institutions.
yeah,
Well, you don't have that same problem with a living trust. If something happens to you in a living trust, suffer from some sort of incapacity, that your successor's trustee steps right in
it's easier. Yeah.
and it's simple and it to get access to money is simple, whereas the power of attorney, there could be all sorts of hurdles before you have access to money. So, recommend highly a living trust just on the incapacity issue. It's so much easier for your successor trustee to step in and help you out financially versus the power of attorney.
Yep.
Okay, I don't have either the advanced healthcare directive, I don't have a power of attorney, and I need the money out of the account. What do I do?
So again, yeah, if there's no power of attorney for finance, no advanced healthcare directive, you don't have any documents, if you do need access to money, then you're gonna have to file for a conservatorship. And that gets filed with the probate court in the county in which you reside.
Talk about a little bit about what a conservatorship is about.
So conservatorship is somebody, typically it's a family member, files a petition for appointment of conservator, and they request the court appoint them to be responsible for your finances. And, generally the court requires a bond. A bond's like an insurance policy in the event that the conservator does something improper with your money. But yeah, so you file the petition, the hearing gets set, 4 or 5 months out.
Does the person who's going to be conserved have to appear in court?
They're supposed to. I mean, there's a lot more mechanisms in place nowadays. Like, for instance, there's a court investigator that goes out. Court investigator is somebody that works for the court that goes out and meets, in person with the proposed conservatee, talks about the conservatorship, tries to educate them a bit about the conservatorship, also tries to determine, do you oppose the establishment of a conservatorship, or are you in support of it? And on top of that, nowadays the court generally appoints counsel for a proposed conservatee. And so there's a list of attorneys that the court has that the court trusts, and they'll say, okay, if the person doesn't have any money, they'll appoint the public defender. But if the person has assets, they're going to appoint somebody off of that private attorney list. And then that attorney also goes out and meets with the proposed conservatee and determines what their wishes are. And I mean, it's gotten the rules have gotten a lot stricter over the years. I mean, Britney Spears, she was under a conservatorship, and that put a spotlight on the law of conservatorships. And in response, the legislature increased the safeguards, for proposed conservatees.
Yeah. You have it under here, LPS conservatorship mental health. Is that because maybe an individual is not taking their drugs? Can you force them to take drugs? Their drugs, for schizophrenia or for a variety of mental illnesses?
No, you can't. I mean, LPS conservatorship is something that's brought by the county. So
What
like
does LPS stand for?
Lantrum Petrus.
Yeah,
It's
Oh, that helped. Okay, thank you.
yeah, I don't remember the name exactly.
it's for mental illness.
Yeah,
Okay, thank you.
so let's say that, yeah, you have a mental breakdown and you're, a threat to yourself, or, you're going to harm yourself.
Or threat to others.
Or threat to others, yeah. So the police would show up and they would, see that something's wrong, and they could take you in, and then the county can decide to pursue an LPS conservatorship over that person. And that's typically they go from year to year. So each year it's reevaluated because it's the ability to put somebody in a locked facility.
Yeah.
And to administer medication against their wishes. So, but again, that's not something that normal people can, just a regular person can file. But we can file the probate conservatorships or limited conservatorships.
Yeah. It's we don't, as a society, we don't know how to handle mental illnesses. We have a population that is on the street, and many of them could qualify under an LPS conservatorship, but the courts are just jammed with issues, and it doesn't. Mental illness can affect all of us, and it's not just those who are poor. I have a client right now that is super wealthy, and their daughter has schizophrenia, and she's uncontrollable. She lives on the street. So It's a real tough situation. Um, when you say conservatorship of the person, is that kind of like the advanced healthcare directive?
I- It's similar, yes. So again, for conservatorships, yeah, there's the conservator of the person and there's a conservator of the estate. Just like, and to expand upon that, conservatorship of the estate is the person that's responsible for the finances.
Next page. Oh, look.
Hey.
Thank you.
Thank you, Don.
Thank you,
I'm
Don.
so glad we have God amongst us.
So yeah, this talks a little bit about yeah, the conservatorship of the person, obviously. Um, and again, so the conservator of the estate doesn't have authority to make, medical decisions, just like the conservator of the person doesn't have the authority to make decisions regarding the person's finances. Typically, it's the same person that's both the conservator of the person and conservator of the estate. But sometimes it's not. Sometimes it's different. Sometimes it's only a conservatorship of the person or only a conservatorship of the estate. It depends on it depends.
Yeah. Well, say you have a living trust and you have a trustee that's handling the trust, but there's no one to handle the medical. So you just get a conservatorship of the person to handle where the person lives, where what they eat, the clothing, the shelter, placement, uh,
Education, yeah, yeah.
a consent to medical treatment. It's
You
huge,
have to show, prove to the court that there's a need, an absolute need.
an absolute need.
Yeah, because the court's going to ask, are there less restrictive alternatives available?
Uh,
And if you have estate planning documents, generally that's a less restrictive alternative.
uh,
But sometimes those documents don't work, and then the court can still appoint a
yeah.
conservator.
Fred, we talked a little bit about your fees as far as to putting together the estate plan and all the documents, and it was for a single person, I believe you said 3,500,
Yeah, 3450.
3,450, and then for a married couple it was 30,
39.50.
39. And so, but a conservatorship, that's an hourly. What is your hourly rate?
So my hourly rate's, well, if it's not litigated, it's 4.95 an hour.
And
If
if
it's
it's
litigated,
litigated,
I'm 5.95 an hour.
595 an hour. And to do a conservatorship, minimum usually around $10,000.
I mean, if you're not doing a temporary, I could get it established for less than that.
But
But you're talking, yeah, at least $5,000. I mean, the initial filing fee alone is it's about $500.
yeah,
That gets
and
paid to
it
the
takes a
court.
lot of time. It's not, in fact, it's much more difficult today than it has been in the
It's
last
it's
20
a
years.
ton of paperwork, and everything has to be filled out
Yeah.
perfectly because the
Let's
court
go to the next slide.
they won't approve it unless it's done right.
Dementia powers.
So yeah, under conservatorship, let's say an individual would benefit from being placed in a locked facility or being uh, administered psychotropic medication. Well, you're not allowed to do lock somebody up against their will. Well, in this type of scenario, you can if you request and obtain dementia powers. And dementia powers, yeah, one you can if the court grants you those powers as the conservator, you can put the individual in a memory care facility that's locked that they can't get out. I mean, sometimes people are like a risk of wandering and roaming and getting lost. That person may benefit from being in a locked facility. And on top of that, you can't force somebody to take psychotropic medication against their will, but you can if you get the dementia, certain dementia powers.
Yeah, every kind of assisted care facility, and that's a marketing term, by the way, not a legal term, has what's called memory care. They have all sorts of different names, and it's for individuals who wander. Sundowner syndrome is individuals at 1, 2, 3 o'clock in the morning, or as soon as the sun goes down, their mental health goes awry and they need to be placed in a secure environment. And the court does not grant these powers easily. You have to, it takes lots of time in front of the judge to fully convince the judge that these powers are needed.
Yeah, you have to
Next,
have a doctor's got to sign under
yeah,
penalty of perjury, all sorts of
yes. And if there's
language.
family issues involved, it can really be a problem.
Yeah.
The hope is that you pick family, you got please, when you pick family members in these positions, talk it over with legal counsel. Because if they don't get along, uh, you've got a bigger mess than just the problem that you have. And most of the problems are family oriented. Now, by the way, 80% or 90% of us are not going to have a problem. The beneficiaries want the money, we want to move on with our lives, but there are 10%, maybe 15% in a community of 3 million. We got issues. So if you got issues in the family, make sure you talk about them with the attorney. Let's go to the next slide. Conservatorship of the estate. We kind of talked about that.
And I
That's
wrote
your
down
money.
that's the standard. The standard for appointment of a conservator to the estate is
Yeah.
you have to prove that they're substantially unable to manage their financial affairs or resist fraud or undue influence.
Yeah. And scammers, there are people out there that promise lotteries. I've had many clients now that can't resist these people who call and they give them money, and the family members have to place them under a conservatorship of the estate
You got to
because,
understand that a conservator, if the court appoints a conservator of the estate, for you, you no longer have access to your money. The conservator is responsible for your money.
yeah, yeah, and they just keep on giving money to these lottery people,
Yeah.
and they can't resist the fraud.
And I've had those cases, and I've even gotten the FBI involved,
Yeah,
and it's just so unbelievably complicated. And they're in different states, and they'll have a house that's empty that the package gets. It blows your mind.
yeah, it's unbelievable. Let's go to the next slide. Resources. Here's that Your Way booklet. Highly recommend. The first one is free, and it helps you talk about the possibility of you needing a somebody to make decisions for you upon incapacity, and you want them to make decisions that you want, not that they want. And what I hear from family most of the time is that, oh, they know what I want, and especially between husband and wives. And my parents are the perfect example. Oh, dad knows what I want. Well, they never talked about it. So when dad had to go into the hospital, my mom didn't know what to do. So, please use the booklet, have a bottle of wine or a glass of wine, and uh, and the Pulse is also there for you. And I'm glad you got the phone numbers and the address. Learn a little bit about it. Your agent needs to know you. Let's go to the next slide.
I think that might be okay. So we got some more information on like the CMA,
Yeah,
California Medical Association.
super. So let's go to the next slide. California Bar Association. What is the National Academy of Elder Law Attorneys?
It's a group. It's a coalition. It's something that you can belong to as an attorney
And they usually focus in
on elder law.
yeah, so Medicare, Social Security, undue influence, etc.
Conservatorships. Yeah.
Yeah, yeah, conservatorships. You wouldn't want to go to an elder law attorney for income taxes, for tax issues. These, you can look up the National Academy of Elder Law Attorneys on the website, and and you can find an attorney in other states or across the country by plugging in the zip code, because every state has different rules. So you need an attorney who's licensed in that state.
Yeah, all this stuff is this area of law is all state driven. I mean, other than the HIPAA, issues, which is federal, generally everything is, the use of a power attorney for finance. Well, it's in the California probate code. Different states have different laws on all this stuff. So you just got to make sure that you're dealing with the right attorney.
If a link does not work, Google the name of the organization, and you should get the correct link just in the event. I think that's your last slide, I
And
believe.
and incidentally, Pete, as a note, I just saw that one and I went and it worked perfectly. I mean,
Okay.
it came up at first and said not available, and then it went straight into it under publications. There it was. So
Okay.
it
Hey,
worked.
let's you're on your Ask First form, you have your phone number, email address. Somebody has a personal question that they want to ask, they can
Last, keep going to the next page.
Oh, okay, we can do
Fred,
that. Yeah.
oh, either way, next page.
and
There.
yeah, that's
That's me.
Fred's contact information.